for Jonathan, just an observation and a question. The observation is, I think you might have more of an ally in Justice Kavanaugh than you think, in light of an article that came out within the last 2 weeks saying that as a result of climate change, the price of beer is going to skyrocket. And I believe in sworn testimony before the Senate, he's indicated some sympathy for that sector of your economy. A
friend of mine at the UCLA Environmental Law Program wrote an article about Kavanaugh and the price of beer, that might switch his position, yes.
I just wanted to clarify my own mind. I should begin by saying that Canadians stand in awe of the ability of your Commerce Clause to expand infinitely. And I'm assuming that the underlying assumption, and perhaps I'm wrong, of your talk is that if you had a president and Congress that were actually determined to resolve problems like this, they would have the authority to do pretty much everything that was necessary, probably pursuant to the Commerce Clause, I'm guessing. But they would have that authority, and that the real problem here is not so much a jurisdictional one as much as a recalcitrant and environmentally laggard administration. And if that's true, and this brings me to the question of the court, do you actually see the court, even in its reconfigured original constructionist form, do you see it actually striking down, or not striking down, but limiting the extent of the Commerce Clause if you actually had legislation in the way that people went after, say, the Affordable Care Act for the actual legislation? It wasn't not just a matter of standing or rules not conforming, that sort of thing. But would they actually go after the ability of the federal government as opposed to just its laggardness now?
Well, that is, I guess I can't say $64 million question anymore. That's a 1950s quiz show term. Multiple hundreds of billion-dollar question, frankly. Certainly, the anti-regulatory foundations of the jurisprudence of Justices Gorsuch and Kavanaugh, and in different ways, Alito and Thomas and Chief Justice Roberts, is founded on an antipathy toward federal executive and executive agency overreach when Congress has not given agencies the authority explicitly to act in a particular way or to occupy a particular realm of regulatory behavior, according to the words of the statute that create the law that give the agency the authority. If you presume, and frankly, the opposition to the EPA's regulation of greenhouse gas, of carbon dioxide from automobile emissions in Massachusetts EPA, the dissent was most angry about this extension of regulatory authority to EPA under the Clean Air Act that was completely untenable. Congress had never intended the EPA to regulate greenhouse gas emissions. That's not what the Clean Air Act says or is capacious enough to do. If, in your example, you hypothesize a new federal statute that comprehensively purports to regulate greenhouse gas emissions from a variety of sectors, mobile and stationary sources, that would, I would think, necessarily require the grant of regulatory authority to more than just one agency, more than the EPA. Certainly, I would think the Department of Energy, the Department of the Interior, possibly the Department of Commerce, as well as the US EPA, would have to have regulatory involvement in this kind of an overarching climate change statute. There would certainly be a great deal more pressure on these so-called original constructionist justices to find fault with that kind of thoughtful, comprehensive, and deliberate congressional action, because that's what they've said is lacking right now, and why no agency has the authority to do this, because existing federal law doesn't cover that. I mean, I'm not comfortable saying no, they would reject it, or yes, they would embrace it. I think it would be a close call. But I also think that a Congress that was able to pass such a law, however differently configured politically than it is now, because it certainly isn't going to happen the way Congress, the House and Senate are currently configured, but a Congress that was configured differently enough to pass a comprehensive climate change law in the United States would necessarily be advertent enough, deliberate enough, thoughtful enough to write up and publish findings of fact, statements of purpose that would address previous constitutional challenges to this kind of authority, the reason why there is an imperative federal need for the entire country to be brought under one overarching federal statute to bring all of these different agency authorities to bear on the problem of climate change. They would cover their you-know-whats every which way to Sunday in terms of setting up the unquestioned challenge from various kinds of business sources to that kind of a law, in the anticipation that they would be getting extraordinary adverse scrutiny from justices like Kavanaugh and Gorsuch and certainly Thomas and Alito. It would be a wonderful thing to behold.
Well, I also had a question for Peter. This is a very practical question, and it relates to these efficiency-based measures that you've talked about that are now in place, and the implementation by the flag state. And you sort of touched on it, I think, in passing it, but I just want to follow up and ask, how does that work in practice when you have something like the Marshall Islands? Do they have the technical competence to deal with this? I can think of other instances in UNCLOS where all sorts of fishing expertise was assumed for some of these island states, and they just didn't have it. Is that something that's being addressed through this proposed fund, or maybe I'm just wrong, maybe there aren't practical issues here, but they strike me as sort of there.
Well, it's a good question. I think that I can talk about what happens in the Canadian context, and in terms of, I think that might be able to be projected to the sort of context of open registers like the Marshall Islands and Panama. So with the Energy Efficiency Design Index, that's an annex to the Marine Pollution Convention. So in Canada, under the Shipping Act, that has been embraced sometimes in whole, sometimes in part within the regulations. So in 2013, Transport Canada did that was embraced in the regulations and sort of embedded in it. So I can only understand that the same thing happens in the Marshall Islands context. When it comes to enforcing something like the Energy Efficiency Design Index, where it's a technical measure that's associated with, it really only occurs either during a vessel refit or vessel construction. So my understanding is that in most cases, a sort of flag state will sort of engage a classification society to ensure a vessel is built in accordance with kind of prescribed IMO standards. And, I would think that in the Marshall Island context or Panama, the same standards would apply. And really, the vessels would be required to carry a certificate that certifies their compliance with that standard. And then when they go to different port states around the world and are required to demonstrate compliance, they do need to show that certificate, otherwise they're subject to penalties. So that's my understanding of the enforcement mechanism. Moving forward, because the sort of Energy Efficiency Design Index has been the centerpiece of the IMO's plan to reduce carbon emissions, at least for the immediate future, there may be greater need for enforcement capacity in those states. But I do think that the open register flag states really rely quite heavily on third-party classification societies. So that's my understanding. But I know for the market-based measures, there is talk about sort of supporting open registers that are a little bit more hands-off with regulations in enforcing them.
Are there any other questions? 312. Well, at this point, I'll first of all ask Pauline to.
Merci beaucoup, Alan. Simplement quelques mots pour vous remercier pour votre présence ici avec nous en salle, également votre présence sur le web. Remercier aussi tous les conférenciers et conférencières pour leur générosité dans leurs propos et dans leurs mots pour avoir produit des textes sur leurs conférences. Également, remercier Environnement Canada qui est derrière cette activité qui a permis qu'elle puisse voir jour, qui la finance. Également, remercier les facultés de droit de l'Université de Calgary et l'Université Laval pour le support qu'ils ont apporté à cet événement, ainsi que l'Institut canadien du droit des ressources et la Chaire de recherche du Canada pour leur soutien également institutionnel à cet événement. Et aussi les personnes qui se retrouvent souvent derrière, qu'on voit moins, mais qui ont été très, très importantes pour que l'événement puisse avoir lieu, à savoir de l'Université de Calgary, Jen Rowe et Nancy, qui était avec elle, également Alan Engelson, et de la Faculté de droit. Je tiens à remercier tout particulièrement Madame Mireille Poulain, Mélanie Dufresne et Nadia Abida. Je vais également vous dire quelques mots sur le matériel donc tous les textes qui ont été déposés par les conférenciers sont traduits dans l'autre langue et sont disponibles sur le site de l'Institut canadien du droit des ressources. De même que dans quelques jours ou quelques semaines, la portion vidéo donc, qui aura été captée des conférences d'aujourd'hui. Et cette année, l'Institut canadien du droit des ressources, en collaboration avec la Chaire de recherche du Canada en droit de l'environnement, m'a révisé un très grand nombre de ces documents de conférences pour qu'ils soient publiés sous forme de livres, tant en anglais qu'en français. Donc, prochainement, vous entendrez parler donc, de ces conférences, de l'environnement devant le tribunal et des textes qui ont été produits à travers ces 8 éditions. Alors, je cède la parole à Alan.
Thank you, Paul. First of all, I would like to thank everyone for their contributions, their insightful questions and comments, and certainly, again, the presenters for their contributions to make this a successful symposium. Secondly, I would like to thank the University of Laval for supporting us in this, I think it's what's been a very informative symposium. Thirdly, by way of an update on the Environment in the Courtroom book, the English edition is to be released by the University of Calgary Press in December. That's the latest as of this week. And, of course, we be working again on the French version that will hopefully be out later in 2019. So with that, I hope you enjoy this wonderful city. Have a great weekend, and we look forward to seeing you at a future environment in the courtroom. Thanks.
Merci beaucoup à vous. Ah, merci.